On the enforcement of this New York City law, it's a little peculiar. Only current employees can bring a civil lawsuit against their employer alleging a violation, even though it seems most likely that for job postings, prospective employees are going to be more likely to be affected. That's not to say, however, that applicants don't have any recourse under this law, because it is part of the New York City human rights law. So anyone who feels aggrieved by a violation of this new requirement can file a complaint with the New York City Commission on Human Rights. The restriction on civil lawsuits is only limited to current employees, is only limited to civil lawsuits. It's not limited and doesn't apply in the case of a complaint with the New York City Commission on Human Rights. Question whether that was intentional or not. I guess I'll just leave it at that. But that's the way the law is written now. The civil penalty for the first offense is capped at $0 if the employer cures the violation within 30 days. So if upon being made aware that they did not include a salary range, or that they didn't include a reasonable salary range in a job posting, in the first instance, the employer can somehow fix the violation within 30 days, then there's no civil penalty for subsequent violations. Or if the employer refuses to fix the violation, then there can be a civil penalty of up to $250,000 per violation. Again, what discretion the Commission on Human Rights will use in those cases remains to be seen. None of this necessarily, however, prevents an employee from making a complaint that they were aggrieved and suffered losses by the violation, in which case they may be able to obtain, for example, lost pay damages, and there could be additional damages, and including fees, attorney's fees, and costs as well.